Right now, joining us from Cornell University is law professor William Jacobson. He has a website called legalinsurrection.com. You want to check it out because there's some really great takes on legal issues in front of us. And Bill Jacobson joins us once again. Good morning, Professor.
Hi, great to be here again.
Appreciate you joining us. You know, last week on the 3rd, March 3rd, Judge Roger Vinson down there in the Federal District Court in Florida, he issued a stay of his original ruling invalidating Obamacare. And this was at the request of the Justice Department. Now, when I first heard the news reports of this on Thursday, I thought it was really interesting because most of the mainstream media reporting this was talking about a big setback for opponents of health care reform. The same judge that ruled the law invalid is now issuing a stay of his order, but only for 7 days. And then later I started hearing people on the conservative side say, well, no, there's more than meets the eye to this. Well, in your opinion, is there more than meets the eye to this?
Well, sure. I mean, if you actually read his order granting the stay, it's very clear that he was taking a very major legal swipe at the Justice Department and at the government's position, because what he did is, in an almost mocking tone, he took what they requested. They made a motion to clarify his prior opinion. And in a somewhat mocking tone, he clarified it by stating that, you know, what I said was pretty clear before. But then what he further did is he took their motion to clarify and he himself turned it into a motion to stay. And what stay means is basically holding off on the implementation of the ruling until there's further appeals. But he did it in a way which really forced the government's hand. He said, I'm going to treat your motion for clarification, even though I think my prior ruling was very clear, as a motion to stay my ruling pending appeal, but I'm going to do that only on the condition that within 7 days you file an expedited appeal either to the Court of Appeals or directly to the Supreme Court. So I think any fair-minded person who reads this order would say this is an enormous win for the states that are challenging the constitutionality, because what it does is it forces the government to do something quickly. And as the judge noted in his opinion, the government has actually been doing everything to not move quickly on this litigation.
Well, isn't it true that even since he issued his first order back in, that was 6 weeks ago, right, that the Justice Department, or actually not the Justice, but the administration, has continued to implement aspects of Obamacare in spite of the fact that his declaration was supposed to act as an injunction?
Right. Well, what the government's done is a little bit disingenuous. They've said that, well, he didn't issue an injunction, and therefore we're not prevented from doing anything. And in a technical sense, that's true. In a literal sense, that's true. But in a substantive sense, it's not really true, because as the judge noted in his first decision, and he noted again in his second decision, that a declaratory judgment, where a judge declares whether something is constitutional or not, has the effect of an injunction. That when a judge declares a law unconstitutional, he doesn't then have to go the next step and say, government, I'm going to stop you from implementing an unconstitutional law. It is presumed that the government, once something has been declared unconstitutional, will not then seek to act upon it. The government here, of course, completely disregarded the first decision, acted like it, didn't understand the first decision, acted like there was something obtuse about the first decision when in fact it was very clear. And he took them to task in that repeatedly throughout his opinion, and I do say it was in a very clearly mocking tone, where he expressed disbelief that in reality they could have misunderstood his prior opinion.
Mm-hmm. Now, among the 26 states that were party to this lawsuit to undo Obamacare, some of them saw his original ruling as great. We're going to stop the brakes on our individual implementation of this law. Others have continued to go along because they want to wait and see how the thing, works out.
Well, they put states in a very difficult position because there are costs imposed to start implementing this law, even if it doesn't take effect for a couple of years. And so states are in a tough position because if they do nothing, if they in fact, say, well, this is the end of it until some court says otherwise, but a year from now, their law is upheld, they're in a very difficult position. On the other hand, if they do spend a lot of money to start implementing these provisions and it is upheld as unconstitutional, they will have thrown money down the drain. And the judge effectively recognized that in his decision. In his second decision particularly, he says the reason this needs to be expedited is both sides have legitimate arguments. It's not that there are frivolous arguments being made on the constitutionality. It's just not for a lower court to be the final ruling on that. If the Supreme Court is going to go and establish essentially new law, that it's going to have to be the Supreme Court. And, the only thing I was a little disappointed is he did order them to do an expedited appeal, but he left them the option of doing it to the Court of Appeals or using this unique, unusual procedure, which does allow parties to go directly to the Supreme Court. I think it would have forced the government's hand a lot more if he had conditioned the stay on them going directly to the Supreme Court, or at least trying to go directly to the Supreme Court.
All right, we need to take a quick break here, and then we'll come back with more, because I want to ask you about the Court of Appeal that would it end up in, and which Court of Appeal when we get back, all right? Law professor William Jacobson, Cornell University, also legalinsurrection.com is our guest here on 1460 KION. We're going to take a quick break, and we'll come right back. Checking traffic on the 10s here on KION. Watch out for a report of fire in the 7300 block of Viewpoint Road in Santa Cruz County. And we have defective traffic signals. This would be SoCal in front of fire station number 1, okay? And so watch out for that. Be careful in that area. That's our traffic on the 10s at 8:21. We're back with more in just a couple of minutes.
Your office copiers. Aren't they wonderful?
I need the copier. Get out of my way.
No, I'm first and it takes too long. I've got an appointment.
Do you still have that dinosaur office copier from 2001?
Oh, the ink is smudging.
I have a presentation and it can't look like this.
That's why Data Flow Business Systems is here to service your business needs. An authorized dealer for Ricoh, which owns and distributes the Savin brand of copiers, as well as Gestetner and Lanier copiers.
I need to squeeze in here to make it to the fax machine.
Improve your employees' workspace and health with copiers and faxes all in one that are not big and bulky.
Oh my gosh, you're a lifesaver.
After 21 years of serving the office equipment needs for the Tri-County area, Dataflow Business Systems is proud to be the only locally owned authorized dealer. If it's a new copy or service to your existing systems, we can handle it. Ricoh, Savin, Gestetner, or Lanier, call us today, 759-8760, or visit us online at startdbs.com.
I'm not comfortable with this. I think Jason should go to college now. I don't want him putting this off. He's already talked to a recruiter. Could you just talk some sense into it?
I understand, but I think if you just listen to him, you'll see his decision makes a whole lot of sense. He wants to go to college right now, but he also wants to serve. That's why he's been talking to a National Guard recruiter.
The National Guard gives young men and women the unique opportunity to serve their country and communities part-time while they attend college.
You know, we've also got to figure out how we're going to pay for all this. The way things are these days, tuition, room and board, they're through the roof. And with our finances...
No, honey, don't worry. He's worked that out with the Guard recruiter, too.
Plus, with the National Guard Scholarship and other financial benefits, college students can graduate debt-free. Get to know what serving in the National Guard can do for your son or daughter. Visit NationalGuard.com.
Sponsored by the California National Guard. Aired by the California Broadcasters Association and this station.
If you've been looking for Pandora jewelry, look no further. You'll find it at Jared, the Galleria of Jewelry.
That's Jared!
Life has its moments. Make them unforgettable with Pandora bracelets, beads, earrings, and charms from Jared. Jared has an outstanding Pandora collection.
It can only be Jared!
Visit Jared March 10th through March 13th and receive a Pandora lobster claw bracelet with a minimum purchase of Pandora charms and jewelry. Visit or contact your local Jared store for details regarding the qualifying purchase.
Prepare to share the goodness. Pick up your 20-piece Chicken McNuggets at McDonald's for just $4.99. That's 20 tasty morsels made with white meat plus your favorite dipping sauce for less than $5. With a tasty deal like that, you can afford to be generous. Price and participation may vary.
Join the KION Morning Traffic Phone Force. You can help be our eyes on the Central Coast roadways. When you see traffic problems happen, call us right away at 831-633-1460. And thanks from 1460KION.com. More stimulating talk radio.
Hey, thanks for joining us. 8:24 is our time here on 1460 KION. Law professor William Jacobson, Cornell University, and also legalinsurrection.com is with us till the bottom of the hour. Professor Jacobson, welcome back to the program.
Hi, how are you?
You're doing good. And, what's interesting about this is that Judge Vinson in the Federal District Court in Florida, I guess it's the Northern Federal District Court, issued this stay of his original ruling. Now, he said 7 days that they have to get it before the appellate court or the Supreme Court. Can the Justice Department bring this to, say, the Ninth Circuit Court of Appeals, where they'd get a very favorable ruling, perhaps, or does it have to stay within the federal district in which Judge Vinson issued the ruling?
They would not have the choice. It will go, the Northern District of Florida is part of the 11th Circuit, and so the appeal would go to the 11th Circuit Court of Appeals. You don't have the choice of shopping for circuit courts.
As much as they would like to.
Yes. Although I'm not sure it would make a difference. Everybody knows this is ending up in the Supreme Court.
Okay.
Either all of the cases or at least one of them. But they're going to the 11th Circuit.
Okay. Now, what happens if they do not have their appeal before the 11th Circuit at the end of the 7 days, which would be the 10th?
Well, that's actually a really interesting question because he granted them a stay, so it would mean the stay would expire and we would be, in a sense, back to square one. His declaratory judgment, he still hasn't issued an injunction, so we would essentially be where we were before the clarification, except now it's been clarified.
Mm-hmm.
So that would then again put the issue to the government as to whether they're going to essentially ignore his declaratory judgment. But I can't imagine that's going to happen. I would have to believe, I forget which day this decision was issued.
It was issued on the 3rd, so
okay.
It has to be done by the 10th.
Yep. So I have to believe that they will file whatever papers are necessary, both to put the appeal before the 11th Circuit and to request that it be expedited. That doesn't mean they're going to have to file their full briefs and everything like that. The 11th Circuit will set that schedule, but they're going to have to request expedited consideration by the 11th Circuit.
Was there any attempt? Now, some people have said, some of the conservative bloggers have claimed that what the Justice Department was trying to do when they went to Judge Vinson was that they were trying to come up with some sort of a trap for him that they could get his earlier ruling invalidated. Do you buy that?
No, I think that I think I'm not really sure why they filed a motion to clarify. Even the judge was somewhat at a loss for that. I don't know if they were trying to lay any sort of trap or what they were doing. Perhaps they were hoping he would then issue an injunction, and that would give them some sort of ability to seek an immediate stay from the appellate court.
Mm-hmm.
But he kind of he was having none of those sort of games. He said, I'm going to treat your motion to clarify, which is a nonsensical motion, as a motion for a stay, and I'm going to give you what you want, but I'm going to turn it on you in a sense and require you to move quickly.
Mm-hmm. One of the things I read over the weekend in researching this was that Judge Kessler, in favor of Obamacare, made a ruling recently where she said that the Commerce Clause does allow the government to, quote, regulate your thinking process. In so many words. In other words, just thinking about economic activity or not economic activity is the purview of the federal government. And that was the last court case to rule on Obamacare and ruling that it is valid, that's a valid extension of the Commerce Clause. Now, what I read, and I thought this is kind of interesting, I want to get your take on it, was that Judge Kessler's ruling is so radical to so many people, even more moderate supporters of Obamacare, on principle, would be pushed away from supporting the law if they realize that the government can use this as a pretext to regulate your thought processes.
Right. Well, what she said was not so much that that the government can regulate your thought process, but that the decision
making.
Right. The decision not to purchase health care is in fact an action that can be regulated. So I think I've got that language right here. She says, making a choice is an affirmative action whether one decides to do something or not do something. They are two sides of the same coin. So I think that's really, a far-fetched sort of notion that the decision not to do something is the same as actually doing something, and that therefore they both can be regulated. I'm not sure it's quite the level of regulating your thinking, but it certainly is regulating your decision-making. And, if I sit here right now and I decide not to do something, I really don't have to do anything. I just have to sit here and mentally make the decision. So to me, that's such a preposterous example, and it just shows how far sometimes you have to stretch to seek to justify this mandate.
Professor, I've got to run here, but I'll just leave you with this. If this stands, the next thing is they'll force you to buy a Chevy Volt.
Or broccoli.
Or broccoli, yeah, that's right. All right. William Jacobson, thanks for joining us on KION. Check out his website, legalinsurrection.com. Watch out for